As Dean Mahoney said, I'm at Kaplan and Drysdale, and I saw Doug Drysdale here. I know Mort Kaplan has been here. It's a pleasure to have fallen into such a hive of Virginians. Not surprisingly, I'm often run into classmates who say, I didn't know you were a tax lawyer. And I said, now I can respond, I'm not, I just play one on TV. The current issue of the UVA Lawyer has a great introduction I've seen from Dean Mahoney, and then two sets of articles. Another interview with myself and Bob Bauer talking about where campaign finance law is now, and then the Dean's introduction says, I haven't seen it yet, a article by Professor Lillian Bevere on the First Amendment. The good news is that Professor Bevere taught me when I was here at the law school. The bad news, for her at least, is that I took her property course and not her First Amendment course. But I do have many happy memories of being at UVA, and have had a chance to come back over the years for a number of events, even to lecture with Professor Dan Ortiz on campaign finance law. So it's good to find the school still in strong hands and doing innovative things, as we heard from the dean. I must say that when I left 30 years ago, I know I wouldn't have predicted, and I don't think most of my classmates would have predicted, that at this reunion year I would be busy submitting testimony to Congress on a campaign finance bill, a piece of legislation known as the Disclose Act of 2012. And I'm pretty sure that my classmates would not have predicted that that legislation would have been written by Senator Sheldon Whitehouse, also a classmate. I'm often asked how, after 25 years as an election lawyer, service as an FEC commissioner, and general counsel to 2 presidential campaigns, I ended up as Stephen Colbert's lawyer on late night television. The answer is, first of all, I was lucky. And the rest of the answer is that it's probably true that 90% of life is just showing up and returning phone calls. I was in my office one day and the phone rang, and it was the staff of the Colbert Report saying, we've been doing some things about PACs, and we understand you know something about PACs. Would you be willing to talk about them? So we had a 45-minute conversation, and at the end of that they said, would you be willing to talk about that with Stephen? And at the end of that conversation he said, would you be willing to come on the show? And so I got on the train, I went to New York, we had a conversation on air about PACs. Before I went on air, I'm sitting there waiting to go in my pancake makeup, and the staff came by sort of nervously saying, I know you haven't done this before, there are just 2 things we need to tell you. The first and the most important is, remember, he's the funny one. The other piece of advice was, now you're going to go out there and there's all this light and there's this crazy audience and there's a lot of noise, and just focus. Listen carefully to him, because as he's talking, you have to identify the question he is asking and answer it. And I thought, UVA has prepared me for this. That's just like a law school exam. You know the subject matter, but you're not sure of the exact question that's coming. The only difference is that it's on nationwide television, and the 5-second pause to think about the answer is a very long time when everyone is looking at you. After the first show, he came back and said, I'd like to pursue this, I'd like to have a PAC and sort of explore how it works and be able to explain this to my audience. Would you be willing to be my lawyer? And I was at that moment not employed by any other candidate or political entity, and I said, certainly, I'd be happy to. Now, I was a little concerned when I went back to Washington. Broke the news to Kaplan and Drysdale. I wasn't quite certain what everyone would think, and my clients and other lawyers. The firm was, along with Dean Mahoney's comment about his children. The firm was absolutely thrilled. As the president of the firm said to me, "This is the first time in 30 years that my kids are excited I work here." Because that means they know I know you. Clients tend to be a little bemused. It's odd to see their lawyer on late night TV, but there's some ratification from the fact that he keeps calling me an expert. As far as other lawyers, my favorite was the election colleague who said to me, "You know, I watched the show the other night, and now I get it." Stephen Colbert does have a knack for taking very complicated legal subjects and hours of staff discussion and research and distilling it into that 4.5-minute Q&A that captures the essence of an issue, explains in layman's language, in a humorous, captivating way what is really going on. I keep thinking as I watch it that he should have been a Supreme Court advocate. It's still, though, I think a serious question as to why a lawyer would risk looking like a fool on nationwide television again and again, sort of out on the high wire without a net. It's not for the money. Kaplan and Drysdale does charge for legal research and creating Delaware shell corporations, but not for my time on the air. Originally, it was probably for the challenge of it. I think it's good for all of us to stretch our comfort zone. When I first told my mother she might want to watch the Colbert Report when I would be on it, and told her she could find it on the Comedy Channel, she said, "The what channel? I hope you're not going to try and be funny." What are mothers for? But the reason I keep doing this is that I think teaching about the law is an important part of our profession. It has seemed to me for years that campaign finance issues are actually interesting. We've had First Amendment Supreme Court cases on campaign finance steadily since 1976. We've seen the advent of soft money, phony issue ads, 527s, McCain-Feingold, and of course, Citizens United. But I do realize in my more grounded moments that not everyone finds all of that exciting. For many people, it can become part of the background noise, part of the back and forth of an election cycle, if it is even noticed. And it can be complex. The complexities of the rules created by the FEC in response to the Supreme Court's decision in Wisconsin Right to Life 1 caused Chief Justice Roberts to exclaim in Wisconsin Right to Life 2, "Enough is enough." But it is complex precisely because this is where two important constitutional values meet, sometimes head-on. The First Amendment, which we all know about, and the existence of a functioning representational government, which we sometimes forget is the whole purpose of the Constitution. And the Supreme Court has recognized repeatedly that the legitimacy of that government is threatened at its core when it is corrupt or even appears to most citizens to be corrupt. The concern with the role of money in elections and consequently in the governing and legislative process, which is the real issue with money in elections, has been present for over 100 years. Since 1907 and the Tillman Act, which banned corporate contributions in federal elections, Congress has been debating when funding sources or amounts may corrupt our elections and thus the legislative processes those elected engage in. It is no secret that President Obama has been complaining about our campaign finance system. One presidential statement caught my eye as I was doing background reading for today. I quote, "All contributions by corporations to any political committee or for any political purpose should be forbidden by law. Directors should not be permitted to use stockholders' money for such purposes." But wait, that wasn't Democratic President Barack Obama. That was Theodore Roosevelt, over 100 years ago. In some ways, it is interesting how little the debate about corruption in politics and the legislative process has changed in that time. But it has changed constitutionally and in our lifetimes. In the past 25 years, the Supreme Court has moved from largely upholding regulation of campaign fundraising and corporate spending to striking it down. The 6-3 Austin decision decrying the corrupting potential of corporate money in elections was succeeded by the Supreme Court's 5-4 decision in McConnell v. FEC, upholding the McCain-Feingold Reform Act, and shortly afterwards by the court's 5-4 decision the other way in Citizens United, striking down McCain-Feingold's regulation of corporate money in elections. Now, I am a critic of much of Citizens United on procedural and constitutional grounds, but that is a subject for another day. What I'd like to focus on right now is where did Citizens United leave us as a democracy? First, Citizens United was decided by a court which, for the first time in U.S. history, has not a single justice who has held elected office. Justice O'Connor, the key vote to uphold McCain-Feingold, had run for office, raised campaign funds, served in the Arizona legislature as majority leader, and I think understood how dangerous and complicated the intersection of campaign money and legislation can be. Other justices show no such deference to Congress. In fact, they appear to think any regulation of campaign finance by Congress is suspect, that it must be nothing more than incumbent protection. Having watched firsthand as insurgents and rank-and-file members of Congress passed McCain-Feingold over the bitter opposition of insiders of both parties and of both political party committees, I did not regard that legislation that way. But more importantly, I think the clear propensity of this court to brush aside Congress's judgment that there is a danger of corruption because of election spending creates a serious institutional barrier to Congress's ability to safeguard the legislative process. In the last 2 years, the Supreme Court has allowed unlimited corporate and labor spending in all elections in the United States, overturning 60 years of federal law and some older state laws in 26 states. It has declared unconstitutional the Arizona public financing system because it provided additional funds to candidates to compensate when they found themselves outspent. The D.C. Circuit has declared unconstitutional the long-standing $5,000 contribution limit to independent expenditure-only political action committees, which decision has resulted in the creation of what we call super PACs, like Stephen Colbert's Americans for a Better Tomorrow tomorrow. All of this has been done in the name of the First Amendment, which as Americans and as Virginia-trained lawyers, we all honor. But one can be a First Amendment absolutist without being absolutely sure what it requires and what it prohibits. Well-meaning and wise people can differ, which I believe argues that at least some deference should be given to Congress, as they are the ones who experience the campaign finance system on a daily basis. My point is not that the court was right in one case or wrong in another, but rather that these are close and complicated issues of constitutional interpretation, and that the court, slashing its way through the campaign finance statutes with a machete, can have dangerous and unforeseen consequences for the stability of our democratic government. I'm occasionally asked questions by reporters or foreign visitors about our campaign finance system, and I have taken to responding that there is now no such system. The laws written by Congress have been so rearranged by various court decisions and by the FEC that they resemble the pieces of a jigsaw puzzle laid out randomly on a table with important pieces missing. This is why the Colbert Report coverage is so successful. It is easy to make fun of a system which claims to require disclosure of money spent to elect or defeat candidates, but in fact provides so many ways around that requirement as to make disclosure optional. A system that says independent expenditures cannot be limited as a matter of constitutional law because they cannot corrupt, because they are totally independent of candidates and parties, when the daily news reports are full of candidates raising funds for these supposedly independent groups, run by the candidates' former employees, using the same polling and advertising vendors as the candidate, with these groups taking unlimited contributions independently from people who then have private meetings with the candidates. This is not how the majority of the court in Citizens United said things would go. They stated that all spending in elections would be fully disclosed, apparently unaware that IRS and FEC regulations provided otherwise. They did not foresee that the DC Circuit would create super PACs a few months later, expressly basing that decision on the logic of Citizens United. The court, lacking anyone who had ever run for office, and not having yet seen the Colbert Report, was apparently unaware of just how coordinated and uncoordinated expenditure could be. In some ways, Citizens United is a great illustration of the law of unintended consequences. But we, as a country, are left in a fix. We have campaign finance practices that both parties and both presidential candidates say they dislike. We have the ability of interests, corporations, unions, wealthy individuals, to threaten members of Congress with unlimited expenditures if they vote the wrong way on legislation before Congress, or in committee where there is even less public scrutiny. If such election spending does occur, the fact that the sources of funding can be kept secret violates what has been a basic bipartisan consensus on election law, both here in the US and around the world, that spending in elections should be transparent. And the public funding system for presidential elections has now completely collapsed, meaning that both major party nominees will spend enormous amounts of time between now and the election raising money, rather than discussing issues, meeting larger numbers of voters, or in the case of one of them, having time to do his day job. In this, they will join the ranks of members of Congress, who now almost uniformly report, after leaving office, that everything was about the money, with phone calls all day and fundraisers every night and every weekend, because they have to raise $50,000 or $100,000 a day. I would like to think that after this election, the problems with the status quo will be overwhelmingly clear to both sides, and a consensus on a new way forward will emerge. But unfortunately, I only believe the first part of that sentence. The problems are clear, but the ability to reach a consensus is not. Look at where we are. Congress is deadlocked on this issue and has been now for some time. Getting a bipartisan agreement and a supermajority of the Senate behind it seems a very heavy lift. The Federal Election Commission is deadlocked, 3-3, all the time on virtually every issue. It cannot even muster a majority of the commission needed to appeal adverse district court decisions or agree to publish notices of proposed rulemakings. The IRS has gone into hiding. It does not want to adjudicate what it views as political disputes between the parties about the use and abuse of the tax laws by 501c4s. The Supreme Court itself is divided 5-4 or 4-5 on these issues, as every recent case demonstrates. In this environment, there's only a little bit of good news. One is that Stephen Colbert will have enough to talk about through this election and beyond. And for this year's UVA graduates, there will be work available on these issues for some time to come. Thank you very much.